we're just going to record the presentation section. I'm going to finish the recording before we get on to questions. So hopefully you'll join us for future events. Very happy for this first one, a very important time to be delivering it with the impending changes. And I'm delighted to hand over to Rachel York.
Thanks, Laura. Yes, thank you, and good to see so many of you today. Thank you for giving up your lunch break. I know it's very sunny outside. So I'm just going to launch straight in so that hopefully, like Laura says, we do have time for some questions at the end. So as you know, 18th of December last year, the Employment Rights Bill received royal assent, and as such, we now have the Employment Rights Act 2025, or the ERA as it's become known. And we saw a number of ERA changes take effect in February this year, but most of those changes were related to the rules around industrial action. In April, on the 6th of April, so in 2.5 weeks' time, we will see a number of other changes which will affect employers more widely, and that's what we're going to focus on today. Most of them will require some action on your part. Some of these actions you may have taken already, and we're going to flag those action points as we go through, and obviously we can pick up with anybody separately afterwards if they need any help with anything. So just starting with changes to family-friendly rights then. So paternity leave is going to become a day one right. So for babies that are due on or after the 5th of April, or for babies that are placed for adoption on or after the 5th of April.
Rachel?
Yes.
I'm going to move your slide.
Yes, thank you for reminding me. There will be no longer be a requirement for partners to have accrued the 26-week service by the usual cut-off point. So by that 15 weeks before the expected week of childbirth, partners will be able to take paternity leave from day one. And it's estimated by the Department for Business and Trade that this is going to affect around 32,000 dads and partners each year. I mean, some have argued that the changes don't go far enough because it's still a relatively short period, 2 weeks of leave. And even after the 6th of April, employees will still need that 26-week service. They still will need 26-week service before they become entitled to statutory paternity pay. Unless obviously the business decide that they do want to pay full or half pay during that period. Now, interestingly, the notice rules haven't changed, so employees will still need to give you notice of entitlement to paternity leave by the 15th week cut-off point, and they will need to confirm their specific leave dates with you 28 days in advance of the leave. Now, obviously for new joiners, they might not be able to meet those deadlines. But in those circumstances, they just have to give you as much notice as is reasonably practicable for them. Okay, so parental leave then, that is also becoming a day one right. So currently, where employees have accrued 1 year's continuous service with the business, they are eligible to take up to 18 weeks unpaid leave per child, up to the child's 18th birthday, albeit that's capped at 4 weeks per year. Now that minimum service requirement again is being removed, and employees will be able to access that right from day one of their employment, but again it remains unpaid. So we think in reality the uptake is going to remain quite low, or if people do take the leave, they will only take 1 or 2 weeks at a time. In practice, people generally tend to book annual leave instead if they need to take leave to look after children, etc. So just moving on to bereaved partners paternity leave then. So this is a new category of extended paternity leave for partners, for parents, whose partner has died during childbirth or within a year of birth. And the new law entitles bereaved partners to take up to 52 weeks unpaid leave in one continuous block. And again, this is the day one right. In terms of notice, then provided that the leave starts within 8 weeks of the bereavement, employees will be able to start their leave immediately by just giving you verbal notice. Now, the numbers who will be impacted or who will need to take this type of leave will thankfully be very small, but we're just highlighting that this leave is going to be available from the 6th of April, and it does essentially plug a gap in existing leave rights. So in terms of action points then on the family-friendly stuff, you'll need to update your policies. You need to remove any mention of minimum service requirements for paternity and parental leave, and obviously highlight this new right to bereaved partners' paternity leave. I think sort of more strategically, you need to decide as a business if you're going to be offering enhanced pay or pay in circumstances where people take these leave, these types of leave. We often see some clients will offer pay, where people have passed their probationary period, for example, but that's something that we can obviously discuss with you afterwards if that's what you're thinking about. And obviously the changes need to be communicated to employees and managers in particular, so they are aware of the new rights. And I think managers in particular need to understand that taking the family leave, even immediately on joining is allowed, it's okay, and employees can't be punished for it, essentially, even if in practice it affects the team or it affects their ability to sort of monitor somebody's performance in the probationary period, which has obviously becoming more and more important given the new unfair dismissal rights, which I will touch on at the end. Okay, so moving on then to, I think what's probably going to be the most significant change in terms of the April tranche of changes, and this is the reforms to the statutory sick pay regime. So the current 3-day waiting period is going to be removed, and SSP is going to be payable from day one of sickness absence. Employees earning below the lower earnings limit will also now become eligible for SSP. So these are quite significant changes where employers are only operating an SSP model. And the government has estimated that it's going to result in 1.3 million additional employees qualifying for SSP. And the aim really is obviously to give more people financial security in the event that they need to be off work, and also reducing the spread of infectious diseases is what the government have put in their sort of their leaflets and things about why they've made these changes. From a business perspective, it's been estimated that the changes will cost £450 million annually, which apparently amounts to around £15 per employee. I don't know how they've done that calculation, but there you go. But in real terms, I think for HR teams, it's going to effectively mean more absence to manage. There's going to need to be a real sharp focus on absence management, absence recording, spotting patterns of absence and tackling those. And we always stress the importance of return to work interviews, but they are really going to be critical moving forward, even where somebody just takes 1 day of absence. And you need to be using those return to work forms to capture the reason for absence accurately. You need to consider whether any adjustments are required to payroll systems to accommodate the pay changes, or obviously liaise with your payroll providers to ensure that they are aware of the changes. Most payroll providers are all over this and are fully aware of the changes, but it's just something to flag if you are operating payroll internally. And then you need to review contracts of employment and sickness policies to remove any references to the 3-day waiting period or a lower earnings limit in respect of SSP. And another thing, if you have an equivalent waiting period in any company sick pay policy, you need to consider whether or not you're going to maintain that or remove it. And me and Laura were just talking about this before. I actually like the idea of keeping waiting days in respect of company sick pay. So people only become entitled to full pay once they've been off for, say, 4, 5, 6, 7 days, because I do think that will reduce the number of short-term absences, or remove the number of people taking 1 or 2 days off just because they feel like it and they know they're going to get full pay. Okay, so the next change I'm going to touch on, again, we don't think in practice there's going to be a significant change, but it is another change that requires an update to your policies, and this is to do with sexual harassment. And essentially, the change is that sexual harassment is going to be added to the list of qualifying disclosures. So the ERA, just to give you the legal spiel, so the ERA will amend the Employment Rights Act 96 to make it clear that workers who blow the whistle on sexual harassment will be able to benefit from whistleblowing protections. And it does that by adding sexual harassment to the list of wrongdoings under the Employment Rights Act 96 that can form the subject matter of a whistleblowing disclosure. So if somebody makes a complaint about sexual harassment, that will now categorically be classed as a protected disclosure. And if you penalise that worker, or are seen to penalise the worker for making that disclosure, not only will they be protected under the Equality Act, they'll also be protected under whistleblowing legislation. And this is just another change aimed at encouraging people to come forward if they experience that type of harassment. So it's in line with other changes that we've seen and are going to see towards the end of the year and in 2027. And just on sort of the policy and updates, you will need, in a whistleblowing policy, you will typically set out what a protected disclosure is and what that includes. So we will now need to add to that a complaint in relation to sexual harassment. We'll also probably need to make an update to any settlement agreements that list out protected disclosures and what they are. But again, that's something that we can help you with. Okay, moving on to redundancy then. So the penalties for not collectively consulting properly. So this is where you are making 20 or more people, well, at the moment, it's where you're making 20 or more people redundant at one establishment. Collective consultation obligations are triggered, and you basically have to follow a much more prescriptive process than if you're just making a smaller number of employees redundant. Now, at the moment, if you get any part of that process wrong, employees can claim what's called a protective award on top of any other complaint that they might be bringing in relation to sort of unfair dismissal. And the maximum award is 90 days pay. That is from the 6th of April, that maximum award is going to be doubling, which is really, really, really significant. So it's going to be a maximum of 180 days pay if you get it wrong. But obviously, if you take advice from us, then you won't get it wrong and it'll all be fine. But this change is really aimed at capturing those, those P&Os, those big employers that, that have been on the news in the past few years, who have sought to just buy off the risk of these claims and do away with collective consultation, essentially. The government have really tried to clamp down on that and make it much more difficult or much more expensive to do that. So it's really just to flag that as, going for collective consultation from the 6th will be much more risky, and there will just be much more emphasis on getting it right. There's also an open consultation, if anybody's particularly keen on responding to government consultations. There's one open at the moment, which is asking for employers for their view on what the new threshold should be for collective consultation obligations. I won't go into too much detail about that, but if you've got particularly strong views on what the triggers should be and you would like to respond, let us know because we can help you with that response. And they've got to be in by the 21st of May, 2026. Okay. Fair Work Agency, the really scary stuff. So there's going to be a new Fair Work Agency established. There's been quite a lot of press coverage about this, or sort of press coverage in HR circles about this, but there's not actually been too much detail released yet about how the agency will work in practice. What we do know is that this will essentially be a new enforcement body. It will bring together current enforcement functions currently spread across bodies such as HMRC and the Gangmasters and Labour Abuse Authority, and it will essentially give it will essentially have the power to recover underpayments of statutory entitlements. So things like holiday pay, national minimum wage. It will have the power to go into workplaces, conduct audits, and essentially bring claims for underpayments where employees haven't traditionally had the appetite to do that, or they haven't been able to do that because they just haven't been able to pull all of the information together. So I think this is quite a significant change. It's definitely raising the risk profile for some of our larger clients. You know, there's a bigger enforcement risk because I think traditionally people have relied on individuals not having the appetite to bring these types of claims. But as I say, the agency will have the power to bring those claims on behalf of people and recover their costs from employers where they have got it wrong. So this is where I sell Laura's services. Laura's got a particularly keen interest and specialism in national minimum wage and holiday pay audits. She's done that for a lot of large employers in her previous roles. So if that is something that you're looking to get advice on, then Laura is your person. Okay, so they're the changes that are sort of coming into force on the 6th of April, but obviously the sort of the big changes that everybody has got in the back of their mind are the changes to the unfair dismissal regime and the extension of the time limit for bringing in employment tribunal claims. They're not happening yet, but the time is now really to start thinking about how those changes are going to apply in practice. And you know, if you take one thing away from today, it is that you and your managers need to be looking at your existing workforce and tackling those employees who are, you know, tackling is the wrong word. I say that as a cynical respondent-friendly employment lawyer, but you need to be looking at your long-term sickness absence cases, your underperformers, you know, your people that are just not performing despite being on a performance improvement plan. And you need to be taking action now before the 1st of January next year, because anybody that is employed now will have protection from unfair dismissal in the not too distant future. So if you are thinking about letting those people go, then as I say, it's time to start thinking about that now, rather than calling us on the 1st of December to say, oh my gosh, we've only got 3 weeks, you know, to do something about it. I feel like all of that sounds quite negative, but hopefully not. And we've got 5 minutes left for questions. So has anybody put any questions in the chat, Laura?
Yes, Rachel. We have had a question which is in relation to the Fair Work Agency. Good question. That there's been some confusion around whether or not it's replacing ACAS. Now, I personally haven't heard that. Have you, Rachel?
No, I haven't. I don't think there are any plans for it to replace ACAS.
I agree. I'd be surprised because I think ACAS are involved in other government plans coming down the line, and hoping to provide some guidance around some of the changes. So I don't think it will replace ACAS, but I'm not surprised by the confusion. Rachel and I were talking about this just before. She mentioned I do a lot of national minimum wage kind of investigations and compliance audits for clients, and currently that's run by HMRC. If any of you, hopefully none of you have had to go through a national minimum wage audit, but they're a bit of a nightmare. And currently they're run by HMRC. My understanding is that it was going to be run by the Fair Work Agency going forwards, but that detail hasn't been provided. We don't know actually whether or not their role is simply going to be to enforce penalties from HMRC, or whether or not they're going to actually take over the investigations themselves. So it's still really unclear, even though it's coming in a matter of weeks. There's not a lot on, there's certainly not a lot on the government websites. There's not a lot of guidance. So I'm not surprised by that confusion. I don't think it will have any impact on ACAS. You know, maybe it would be good if it did, because I think we probably need some more people in the ACAS process, but I don't think it will. I think that was our only question, Rach. Let me just make sure I'm not missing anyone else's questions. Thank you very much, Rachel. That was really helpful. Helpful presentation, good explanation. I have to say, a couple of those, the bereaved partners leave, that had sort of passed me by. I think that's you know, that's coming in so soon. It's interesting after all this time that we you know, all this build up to the changes, that they are now imminent. We're literally a matter of weeks away from the first ones, other than the industrial action ones that came in February. We're you know, weeks away from the ones that are going to impact the majority of employees. And I thought just a couple of points I picked up on that you discussed. So one was obviously that it is relating to existing workforce. I mean, anybody joining in summer of this year, so is it for 1st of July this year?
Yeah.
Essentially, you can consider them to be on a 6-month probation period, because they're the people that are going to be gaining the rights. But of course, anybody that's employed now as well, we want to be looking at, maybe looking at performance processes and seeing if they are you know, tight enough. And the other one was just the sexual harassment point. I mean, again, we discussed it before, didn't we, Rachel? And to make it a specific protected disclosure doesn't feel from a legal perspective that it's going to change very much, because I think it would have been covered under the general disclosures anyway. If somebody claims sexual harassment and then you penalise them for it, you would expect that to be contrary to the law. But I think it just shows us again this real focus on tackling sexual harassment, which, you know, goes in line with last year's changes to proactively prevent sexual harassment and the requirement to do risk assessments and that kind of thing, you know, which is leading into more and more queries around sexual harassment that we're seeing. So they were kind of the key points that I pulled out of it. I thought really useful. Obviously, if anybody does need any help with updating, I mean, what we discussed there was updates to policies, updates to contracts, and even updates to settlement agreement templates. If anyone does want any help, obviously, please do get in touch with us. Or just to discuss anything else that we've discussed today, and also any future topics. As I said, it's going to be this sort of short, informal kind of format, and we just love to get everybody's thoughts and everybody involved. But other than that, I think just thank you very much, everyone, for joining.
Yeah,
hopefully
and I think
see you on the next one.
I think just a quick one, Laura, next time we are going to, and I've said this to a few of my clients already, we're going to send the invites directly as calendar team invites, so they will just go straight into your calendar. So yeah, thank you all again for joining.
Thanks, everyone.
Thank you. Have a good day. Bye. Bye.
Thank you.
Bye.